Okay, good evening, everybody. Can you hear me?
Yes, we can hear you.
Hello, good evening. We can hear you.
Oh, good evening. Sorry, I can't put on my video because there's a power outage at my house right now, but I hope you guys can hear me.
Yes,
Can
loud
you hear me?
and clear, please.
Okay. Good evening, everybody. My name is Delight Chidehim, and I will be the moderator for this session. First off, this is JIIPCC AI mentorship program. So far so good. I want to ask some of the mentees how the program has been for you. What have you been able to learn? Have you been able to learn? I can see God's love, Kamalo. You're so happy to be here. So can I hear how this section has been for you? How this program has been so far for you?
Okay, hello everyone. Good evening.
Good evening.
I'd say I don't know. I think I look forward to AI class most of the time. I was really just enthusiastic about AI and then came into the program. But now it's more like every AI class we have amazing learn and learn some more in AI class. It's really been amazing. I think the organizers, think our mentors, they've been amazing. Right now, we're forming AI experts in training. The world we're coming.
Okay.
Thank you. I'm done, please. Yeah.
Okay, I'm happy you're having a nice time learning from AI experts around the world, because this is not just a Nigerian based or African based program. You're getting to learn from people around the world. And I can see that most of our mentors are here already. So let's get into the business of the day. Okay, for sure I can see Mr. Benjamin Mark on the call. Can you all hear me?
Yes, ma'am.
Okay.
Yes, please, we can hear you.
Okay, so before we get into the program, I would just like to give a quick review of what this mentorship program is about. We all know that JIIPCC mentorship program is a quarterly program for students and young professionals across Africa that gives mentees the opportunity to access valuable advice, training, network, internship, and lots more from experienced mentors. It seeks to encourage continuous training, development, and evolution in Africa and around the world. And this program has various objectives. The objectives include to transform mentees into mentors and leaders for the next generation, to facilitate further mentorship, internships, scholarships, and job placements for the mentees, to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders, to provide easy access to quality professional guidance, training, and resource materials for students and young professionals in Africa. So as regards to facilitate further mentorship, internship, scholarship, and job placements for the mentees. I was once a JIIPCC mentee, and I can tell you that this whole program really helped you. Like, if for real you're serious about it, I promise you that you gain a whole lot from it. Because I remember having a 30 minutes mentorship section with my best mentor, and I was able to be tutored by this mentor. This is what JIIPCC program affords you. So please, mentees, be serious with it. Don't take it for child's play. Be serious with every process here because it goes a long way. And try to reach out to your friends because you guys have been grouped. Try to reach out to many people as possible and connect with them. Do you understand? Can you hear me?
We can
Yes,
hear you,
please.
Delight. Continue.
Okay, fair enough. So we already know the courses because I know like before you registered for the AI course on JIIPCC, you were able to see like different courses being afforded, right? Can you guys hear me?
Yes, very correct. Very correct.
Yes,
You're
yes.
correct.
So
Just
like yeah, so I just want to make sure like you guys, like you are not forced to pick AI. It was your personal decision because there were like other other courses available: intellectual property, energy industry, fintech, health tech, and the rest of them all. But you are able to choose AI, and I pray you listen attentively and get the most out of it. So we'll be introducing I've already spoken about this 30 minutes one-on-one mentorship with your favorite mentor. Trust me, this particular session like is mind-blowing because you get to talk to your mentor directly. Like imagine speaking to mentors, like people around, like you know what networking is now. I don't need to preach to you about networking and the power of networking. So this whole process like just helps you, you know, improves your thinking faculty, your horizon, and you become that value-driven person. Like when you speak, people are like, wow, this person like really knows a lot about this particular area of law or anything. Do you understand? So sorry, I think there's a little network glitch at my end. Sorry.
okay. Our first mentor for today is Magdalena Koni. Magdalena is a key member of AIQ's executive leadership team, responsible for the oversight of the legal governance and departments, including business structure and operations. She is part of the team that brought AIQ into fruition, drawing on her vast international experience as an advisor to public and private organizations, IT integration and implementation, strategic IT and business process outsourcing, graduate degree in law, and was accepted as a member of the Law Society of England in September 2021. Upon completion of her training at Smith LLP, where she was a member of the commercial technology and outsourcing team specializing in ICT and outsourcing projects. Thank you very much for joining us today. Please join me in welcoming Ms. Magdalena Koenig. By Thank you very much. Our second mentor for today is Mr. Benjamin Mark. Benjamin Mark is the patent storyteller, TM. Many artificial intelligence companies can generate complex technologies that are confusing for others to understand. Benjamin assists AI companies in building their patent strategy and clearly tells the story of the invention of their stakeholders and to the patent offices. Please contact Benjamin for the white paper on AI patents. Okay, we take note of that. Benjamin is a partner of Rideout and Lindy LLP in the firm's Toronto office. His practice is principally directed toward patent drafting and publication, with an emphasis on the field of AI, machine learning, blockchain, crypto, non-fungible token, NFTs, metaverse, and extended reality, telecommunication, signal processing, biomedical, computer, and electricals. Benjamin is a graduate of the biomedical electrical engineering stream of the engineering science program at the University of Toronto. He previously worked as a research engineer at a Toronto area hospital, where he was involved in development of medical imaging devices. Thank you very much for joining us today, Mr. Benjamin Mark. We are so happy to have you here, and join us in welcoming Mr. Mark by sending your reactions on the chat box. Um, Also, we are having Mr. Matt Harvey on the call today as a mentor. Thank you very much for joining us today, Mr. Matt. We can see his video smiling. Thank you very much. We are also happy to have you here. WLG UK LLP, advising on AI across all sectors. He is the co-editor of the Law of Artificial Intelligence, Suites and Maxwell. He is a trusted intellectual property advisor, especially for clients with complex patent disputes, including SEP, brand litigation, legal 500, has described him as standout and absolutely superb for what you do, Mr. Matt Harvey. We are so happy to see all this that you've accomplished and all these recommendations. His cases have involved video compression, telecommunications, 2D, 3D, LTE, DSL, and other standards, aircraft design, software, algorithm training, consumer share training platform, 3D modeling, consumer electronics, inkjet printer, location sensing, and traffic analysis. He has extensive experience in the healthcare and life science work, including monoclonal antibodies, biosimilar toxin, medical devices, and cosmetics. He has handled clearances and disputes involving copyright, trademark design, and confidential designs for clients in the aerospace, retail, fashion, automotive, and financial service sector. He successfully defended the Kennedy's Trust for Rheumatology research in the UK's first biosimilar dispute and helped win Fujifilm Kyowa Training Biologics Code Limited, the first UK Arrow declaration. Thank you very much for joining us today, and thank you very much for all that you've done so far. Keep doing the good work, and we are so happy to have you here today, Mr. Matt Harvey. Okay, and lastly, our last mentor for today, our fifth mentor mentor is Mr. Felix Ologbonyo. That's correctly. Felix is a communications and technology company. It provides strategic and bespoke legal solutions to the business across all its divisions and including subsidiaries. He equally sits on the panel of neutrals at the Lagos Multi-Door Courthouse, the first and foremost court-connected mediation center in Africa, where he has mediated over 120 cases. He was legal manager with Nestle Central, West and East Africa for almost 8 years, where he served as special legal advisor to antitrust, electronics, commerce, data privacy and protection, and technology law. He holds a bachelor degree in law, a Bachelor of Law degree from the University of Ilorin, from the Nigerian, a BL from the Nigerian Law School, advanced certificates in intellectual property management from World Intellectual Property Academy, Geneva, 2 master's degrees in law from the University of Lagos, certificates in law and artificial intelligence from European University Institute, Italy. In addition to other professional qualifications, he currently serves as one of the members of the Committee on National Artificial Intelligence Policy set up by the Minister of Communication and Digital Economy to draft the Nigerian policy on artificial intelligence. Wow. Thank you very much for joining us today, Mr. Felix. We are so happy to have you on the call. We look forward to learning from you and also asking you some questions regarding the topic for today. Once again, I'll be introducing the topic for today to everyone: intellectual property protection of artificial intelligence and also ChatGPT. Thank you very much, all our mentors. We are so happy to have you on the call. I think I can hand over to our moderator if she's available. I'll just keep going on. Okay, quickly we'll be calling on our first mentor for today, Mr. Matt. Mr. Matt, you have the floor, Mr. Matt Harvey, to mentor us on the course, on the topic for today, intellectual property protection of AI and ChatGPT. Mr. Matt, you are
Thank you very much. Hi. No, I'm unmuted now, I hope. Can you hear me okay?
Yeah, we can hear you.
Yeah, thanks so much. So yeah, I'll just talk a little bit about that topic. So I've been following AI now closely since about, I guess, 2011. And I would say in that time, we've seen huge developments, a lot around the visual space. So we've seen a team in Toronto in 2012 make huge advances with a form of artificial intelligence called machine learning, and the use of a neural network to solve previously complex or intractable problems. So things like vision and language processing have really been not solved in terms of finding the underlying principles, but by using training data to allow the machine to figure out for itself strategies or correlations in order to be able to, what we've seen, produce very compelling text and images. And since about 2014, we've had the term generative AI. And I would say in the last 6 months, that has become a massive buzzword and increasingly an area of huge interest to IP lawyers. And that area of interest is focused at the moment around 2 particular issues. The first is whether the outputs are protectable in IP. And there are 2 forms of output there. One is where you say the machine has done all the work, and whether that is protectable. And to the extent we're talking about patents, I think it is largely established in every major jurisdiction that you can't get a patent if it has been solely created by AI. When it comes to images or other copyright works generated by AI, there are a handful of jurisdictions which say that they offer either copyright or a special form of protection. The UK is among those, alongside Ireland, India, South Africa, and Hong Kong. And the Ukraine, as of this year, offers a special form of protection for computer-generated works. But that is very rare. And even in many of those jurisdictions, so the UK and Ireland, there's actually some legal uncertainty as to whether the law would work in practice for various complicated reasons. The second general area here is where a creative person, an artist or an author, has used an AI to assist them to generate something. And that is a debate ongoing as well. And in the States, in the United States, there's a case of particular interest, which was unfortunately resolved essentially yesterday. And that is where an artist used a whole series of prompts and editing and selection and curation to create a graphic novel or a comic book using generative AI. They attempted to register this work with the United States Copyright Office. They initially registered it, and then once they had learned, I think probably from the media, that a generative AI had been used by the artist, they then asked for more details of how they had come about their method to create the work. And I think as of yesterday or early today, it has revoked the copyright in the images produced using AI, but has allowed the author/artist to retain copyright in the words and some other facets of the work. So we are at a crossroads here where many countries are debating whether to allow protection for such works, and that I would say is an economic question, whether we need protection for such works practically to get the desired outcomes for society. And it is also a moral question, and copyright in many countries is considered an author's right, and one which is closely linked to being human and should not be extended to machines. And then the final topic here for generative AI, such as ChatGPT, is the question of training data. So ChatGPT and other generative AI has increasingly been trained on essentially the entire public internet. So they have taken databases such as the Common Crawl, which is an attempt to capture literally the entire public internet, and they've trained it on that. And there are now ongoing cases in the United States and in the United Kingdom to decide whether the copying of copyright images involved in collecting that training data is in fact copyright infringement, or whether there's some sort of exception that allows them to do that. So that will be a very interesting area of the law in the next 12 to 18 months. So on that note, I'll hand over to the next participant. Thank you.
Thank you very much, Mr. Matt. I'll be giving the floor to our moderator for today. I'm just the backup moderator, so I think she's on the call now. You can continue. Delight. Delight, are you on the call? Okay, I can't see her, so I'll call on the next mentor immediately, Mr. Benjamin. Benjamin, the floor is yours on the topic.
Oh, thank you.
Intellectual property protection of AI.
Yeah, thank you, everyone, and of course, thanks to Juliana for setting this up. I'll raise a few points, and then maybe I'll have some feedback after the presentations. Yeah, I can speak briefly to, I guess, the AI patent landscape and how it's sort of evolved, since many of you are sort of in the weeds and chat GPT. Maybe we'll step back a bit and the sort of patent framework. I'll talk about US just because US is a large patent market and patent system. I mean, in the US, it was fairly simple. Around the 80s, let's say, they decided if you put in a computer, if you claimed a computer in the patent, then that was fine. You could they would count that as patentable subject matter, and then you would still need to prove it was new and inventive or non-obvious. But at least you didn't have to worry too much about whether it was technical enough. That was the good days until about the mid 2000s when practitioners and patent owners were trying to hide business methods for the most part and ideas, algorithms as well into computers. So there was some pushback from the patent office and the courts saying that wait a minute, you can't just put ideas into a computer and try to get a patent for that. So that reaches to about the same time, of course, as Matt mentioned, about early 2010s when AI started encroaching up. Now we have ideas that simulate human function, whether it's artistry or making decisions or trying to get better accuracy on whatever weather patterns. Now AI has cropped up, and AI is done on a computer, and the calculations are complex, right? So, and there were some earlier cases that just said, yes, if you put in a neural network, that sometimes is technical enough. That was some of the earlier cases, and now it seems, now that it's a little more pervasive, I don't know if you could just say neural network to get a patent based on that might be trying to mimic human function or complicated decisions through your patent. So that's sort of where we are now. It's kind of balanced. Like it seems like it is fairer that things that do deserve to be technical and patented are getting through, and things that just seem to be ideas or abstract thoughts do not seem to be getting through. And of course, yeah, there's all the principles that that Matt and others have spoke about earlier. Things about, well, what do you do with that trained model, right? It's really just a bunch of weights on the neural network. It's not really the inputs, it's not really the outputs, but you have this trained model, and that in itself is code. It has value. Someone created it. And then what happens to the inputs and outputs that come out of it? So that's sort of, I guess, the history of the patent law. And yeah, I think there's some interesting points that maybe we can raise at the end after the presentation. So that's sort of the history of software patents and where they are in AI. And I don't know if you can just say, a machine learning for this to get the patent. You may need to prove out more in terms of the disclosure and the technical effect of what you're doing. So I think that's a good introduction.
Thank you very much, Mr. Mark, for that beautiful presentation on the topic for today. I'll be calling on Mr. Felix. I don't know if you're still on the call. Mr. Felix can also, the floor is yours. Can you hear me, please?
Can you hear me now?
Yes, we can hear you,
Yes,
sir.
you can say loud and clear.
Yes, sir.
Okay, so that's good. So thank you so much, everyone. And let me especially thank Matt and Benjamin for the succinct and insightful introduction. I will not try to repeat what they have said, but just add a few points to what they have said and look forward to the introduction that will be coming from the participants. I think with respect to the issue of IP and artificial intelligence, just building on what Matt earlier said, it's an evolving area of law, and we'll continue to see how the law continues to evolve in this regard. Now, when you talk about the ownership of IP generated by artificial intelligence or computer devices, obviously, world over, I think currently there's no country that's conferred, let me say, legal personality on any form of artificial intelligence. And so by logical reasoning, it does follows that it's probably going to be impossible legally as we speak for an artificial intelligence device to actually own an IP, whether or not it is conclusively generated by such artificial intelligence device. But I think we can continue to explore the frontiers of law in this regard and look at the possibility, instead of leaving such intellectual property in whatever form this time generated by AI to being what you call in company law as bona vacantia, in the sense that it is ownerless and cannot be traced to anybody. I personally believe that artificial intelligence in itself is actually intellectual property. And I will explain what I mean by this. It is intellectual property because it was actually configured and put together by a human being who is recognized to be a legal person in law. And if the chain of creation is not broken to the extent that the coming together, or let me say the formation and configuration of such artificial intelligence device is traceable to a particular person, then I could also argue that the frontier of law be extended to the extent that any intellectual property created by artificial intelligence device should actually be traceable for the purposes of establishing ownership to the person who created the artificial intelligence in the first place. And I think this will bring some order to the space and prevent a situation where you have what is actually ordinarily protectable by law, save for the fact that artificial intelligence actually created such IP will be left unprotectable. And that will may to some extent discourage innovation in this regard. But like we all know, the law is evolving, and this aspect is not fully known by anyone that is even on this call. I will continue to argue and continue to explain how to advance the position of law in this regard. Then I want to speak just about the ChatGPT before I run off, so that I can give room for presentation that we can deal with questions that will be arising from the presentation. We know, just like I think Matt and Benjamin have pointed out, this is actually a form of chatbot, which uses data that have been programmed, and it's a form of machine learning. But again, when you talk about, I've seen some of the questions sent to the extent that, is it possible that this is going to lead to maybe redundancy in the place of work and all that? But I believe that this advancement or this innovation is most likely, and of course that has been proven, that is going to improve efficiency and not lead to redundancy. But again, there are a lot of legal issues related to this. We can talk about the accuracy of data being provided by this chatbot, in the sense that there's something you call artificial intelligence hallucination. This is just going to, yes, as accurate as it may appear to be, and this accuracy is dependent on the data available to such chatbot as at the time when questions or conversation is actually occurring. And in such instance, there's a possibility that the accuracy may be limited based on the information available to that device at that point. So we still have a lot of limitation in
very much, Mr. Felix. I don't know if the lights can continue moderating, or I'll just go ahead. Can you all hear me?
Okay.
Yes, sir. Although you're breaking, though, it's not very clear.
Can you hear me?
Yes, we can hear you.
Yes, Delight, I can hear you, please.
Oh, okay. Thank you so much, Mr. Felix, for such an amazing section. Before we continue, I want us to acknowledge Mr. Gabriel, one of our profound mentors, and if he has anything to say to us.
Thank you. I just today I came as a mentee.
Do you want help?
Today I came, like I said earlier, I came as a mentee today. I just want to learn. I can see Matt Harvey and the other mentors, and I would have probably made a few comments on ChatGPT, but I guess I'll just wait till till I get the presentations from the mentees. Then I can make my contribution. So today I'll just learn from other mentors. Thank you so much.
Okay, sir. Thank you, sir. So, mentees, is your time to speak. We've heard from our mentors. It's time for us to learn from you, the mentees. I know the AI mentorship group program. You guys are grouped into 2 teams, so you have 7 minutes each for your presentation. So, team A, can we get started? Members of...
Okay, hello, good evening, everyone. Please, can you hello, good evening.
Yeah, we can hear you.
Okay, my name is Kamalo Gotslov, and I'll be presenting for Group 1. Quickly, I'll be sharing my slide. And our topic for today for Group 1 is AI and artificial intelligence. It's one beautiful topic, and we're so happy that we're handling that. Okay, so quickly we'll get into this slide. Okay, for a while we've been speaking so much about AI, and I think we can quickly run. I thank God that our mentors have spoken quite some things about the topic. So as we have introduction, we know the truth that everyone who wants to be any creative, any inventor, the main thing they're looking for is a hope of monetizing, protecting, or exploiting their creation. No businessman, no businesswoman wants to go into any business that is not profitable. So that's why in their inventions, in their creations, they want to ensure that these things have cost them sleepless nights, these painstakingly innovative processes are actually beneficial to them. That's where intellectual property comes into play. So what then is intellectual property? Majorly, we say it deals with intangible creations of man, creations that come from man's intellect, things you can think, not like our real property we have in terms of land. It's something that man has to create from his own intellect. God has blessed us with so much intellect, and how well can man create from his intellect? Now, the ability to monetize, to protect this intellect with your economic and moral gains for a creator or investor is your intellectual property right. So moving forward, so do we basically know that in the IP, in the AI space, there is about over 340,000 patent families since 1960 till now, related to 2018 rather, related to AI. It's fantastic, right? That's how much it's actually growing. That's AI and IP. So then in the IP, in the AI family and back to IP, we ask ourselves, what kinds of IP do we have? There's several of them. But then which ones really relates to AI? We have copyrights, patents, trademarks, and industrial designs and trade secrets. So quickly we'll see how to move into them. IP and AI, what's the romance? What's the dance between the both of them? Copyright. Copyright basically refers to original works of an artist or an author. It could be a dramatic work, an artistic work, a literary work, a musical work. The major thing that copyright looks for is the fact that that work must be original and must be in a fixed medium. Copyright IP does not protect ideas. So if it's in your brain, if it's in your mind, it's not functional. Until you actually bring it out into a fixed medium and it's an original work, then copyright could protect you. What kind of AI can be protected by copyright? Every AI comes from the roots, codes, source codes, algorithms, data. These are all copyrights protected because by the time the programmer thinks about it and then puts it into a fixed medium, the typing of the code, the preparation of the algorithm, the graphics designs that are done, they fall into artistic works, they fall into literary works, and are protected by copyright. Basically, countries like Nigeria, copyright is automatic. Once the work is done and put in a fixed medium and it's actually an original work, it's already protected by copyright. And at death, it can stay for 70 years for an individual, then bring a work to for a company 50 years afterwards. We move into patents. Patents majorly are inventions. So when you think of patents, think of inventions. It must go through an inventive process. It's a novel invention. It's new. It has not been there. It's something that can be put into the industry, something that can be used to probably make life easier to work over things. Is it novel? Is it new? Is it an invention? Or is it an upgrade of an invention? That's where patent comes into play. And then what is patent looking at? How novel is that work? Did it go through an inventive process? Can it actually be protected by patents? And it's a place like Nigeria, we use the first to file principle. He who files first for that patent actually gets protected by the patent. As long as you file first, is yours. And then patents, what's the lifespan? 20 years after protection, because come on, it's one has patents for life. Let's imagine how that goes. Then trademark. Trademark is one part you see a whole lot in AI. Trademark is an IP that protects your logos, your slogans, your designs, your signs, your colors, your marks, as long as it's distinctive and unique to your brand. When you see the Google name and the way it's put through, or you see IBM looks so simple, but then that's trademarked. When you look at the Amazon design, that's trademarked. So most of our AIs, for this to be separated from one to another, for example, Apple and Siri, the name is trademarked. How then can it work? For country, normally AI trademark is for life in Nigeria. When you register for the first 7 years and then you renew 14 years continuously, trademark can go for life. Then we have trade secrets, very, very important. Trade secrets, basically, there's no, should I say, means of applying to register trade secrets. Trade secrets, as long as the particular idea remains a secret, as long as it's not out to the public, it remains a secret, it's protected by trade secrets. What kind of AI then can we say IP can protect as per trade secrets? The idea, the code, the AI data, what makes this AI better than this AI? These are trade secrets. Why wouldn't Apple and Siri tell Microsoft how to actually go about what they have? These are trade secrets. And if anyone steals someone's trade secrets that is not made public, you can actually seek redress in court for that. Are there companies actually enjoying IP protection? Of course. Apple, I've been mentioning Siri for a while. Although there was a case recently for a while about Apple and China with regard when it comes to IP protections. Apple enjoys that. IBM has one of the, I think, the most patents now. We have Google doing amazing things. Then we have Baidu. Baidu is also leading in patent registration. It has an AI that works with hospitals and healthcare. Apple has about 7,254 patents registered. Amazon as well enjoys its IP with regards to its designs, its new creations, is also bringing forth. So I'll be moving forward from there. Why then do AI inventors need to actually have IP. It protects your invention, the defense. IP can be a defense for an innovator in the AI space. It protects your invention. Think of what happened with China and Apple. Then monetize. In IP, we're not saying just protect. How can you make money from it? Selling franchise. So Apple can choose to sell the franchise for the AI, for the IP they have, the rights they have in Siri. It's another company to exploit for that period of time. You make money through franchising, through the license you actually give out. Monopoly of exploitation, as long as your IP is protected in that AI, you alone can enjoy it. Anyone who comes to actually do the same thing you've protected, you go to number one benefit, you protect your right. That's why we need to police it. And then finally, incentives for inventors. Nobody wants to create an AI and then the world begins to use it and they're not benefiting from it. IP comes in to say, don't worry, we've got you covered. We are going to make sure that you're protected. And that protection, where you can monetize, you can monopolize, you can protect, it makes other inventors and creatives want to do more in the AI space. This question is the most mind-blowing when it comes to AI and IP. Should IP afford AI any protection? For some years now, it's the major problem we've had, because if you want to give any kind of protection to works developed by AI on its own, we know there are two schools of thoughts. The ones that say, okay, works that are generated only by the AI itself without any human help, and works that an author, thank God Mr. Martha said that earlier, an author gets to work on and then he has an assistance of the AI. And then we ask ourselves, what is the bedrock of IP? IP is saying human intellect, how to make humans enjoy for what they've actually put through. If AI begins to enjoy that protection, it's going to affect the roots of IP. Is IP ready to expand to meet AI as per the laws, or will it remain restricted? That's the affects the question of should we afford AI protections, IP protections to AI inventions? What are the challenges of AI inventions basically now and IP protections? Ownership. Who owns that work? There was the idea, a problem of a painting that was made, and the issue was who owns the painting, because the AI got the painting.
That's love. You have 2 minutes more.
Thank you. I don't have no time. The AI got that invention from different sources. How then do we know the owner of that invention? Because copyrights might know, aside countries like USA, New Zealand, that have brought laws to say, okay, fine, AI can enjoy such protections. How about other companies that do not give such protections? Infringement. How then do you actually protect where AI is giving IP protection and then infringes on someone else's IP? What happens in that scenario? How can you then penalize the IP the AI for infringing on someone's IP? Liability challenge. Who are you going to hold responsible? The creator or the AI itself? Existing laws. Most of our laws are not moving fast enough to meet the evolving nature of AI. And especially the IP law, if countries like USA, New Zealand, Ireland are doing well to actually move faster, how about other countries that are not? In conclusion, give unto Caesar what belongs to Caesar. In my reading, this recommendation, I think I go with, if a creator is doing something, an inventor, it's his own AI. I believe he should enjoy from the IP, whatever that AI creates, because the AI is his own creation. We are God's creation, and God gets the glory for the things we do on earth. So why then can't a creative and an inventor actually benefit? Why should the AI be the one benefiting alone? So I believe that over time we'll get to go through this fight and this phase, and we'll know where we stand. For now, thank you very much, and that'll be all for today. Thank you very much.
Okay, that was a wonderful presentation. God love Kumalo and members of Group 1. That was a very wonderful presentation. Being an IP enthusiast, I understand all your worries, because like this particular issue about AI and IP, like I think I had an article I was working on as regards this, and I must say, like, the issue is really mind-blowing. There's a lot of issues, there's a lot of controversies as regards IP and AI, a whole lot of controversies. Well, that was a very wonderful presentation, very, very wonderful presentation. Then I'll move on to group 2. Hope you're on board for your presentation.
Good evening. Yes, we are ready for the presentation. I'll be sharing my screen.
Okay, please. Okay, go ahead.
Good day, mentors, mentees, and the moderator. My name is Cyril Oyindikachi Cindy, and I'll be representing Group 2. Our topic this evening will be ChatGPT and the examples. As a way of introduction, I would like to state that technological advancements have gotten to a point where things that were basically impossible just a few years ago are now becoming the new norm. Now, one of these ancient impossibilities is what we now know as ChatGPT. What is ChatGPT? ChatGPT is an acronym for Chat Generative Pre-trained Transformer. It's a chat box developed by OpenAI that was launched about 3 months ago on the 30th of November 2022. Basically, what it does is that it utilizes artificial intelligence to interact with human users in an almost human-like manner. It is a state-of-the-art natural language processing model that uses a neural network architecture to generate human-like responses to a given input. It is capable of understanding the context of a conversation and also generating responses that fit naturally with what have been said. One thing I found interesting while doing my research on ChatGPT is that it is fine-tuned from a model in the GPT 3.5 series, which is one of the largest and most advanced language models in the world. Now, this leads us to the question, what is the difference between GPT-3 and ChatGPT? Well, for one thing, ChatGPT is a variant of GPT-3, so it is relatively smaller and therefore faster than GPT-3. Also, ChatGPT is much more readily available for the public, but GPT-3 is reserved for a more considered use. And as we have noted before, one of the major characteristics of ChatGPT is its ability to use human feedback in training so as to make the output sound more human-like. However, GPT-3, on the other hand, may not always produce an output that is consistent with human expectations. With that being said, how does ChatGPT actually work? Well, it is pertinent to remind ourselves that ChatGPT represents a significant improvement over GPT-3. And ChatGPT is a dialogue-based language model designed for generating human-like text in response to human input. So how does it actually work? ChatGPT collects data in order to train a supervised policy model, or what is known as SFT. Now, the goal of this data collection is to learn an objective function directly from the data. And once that function is learned, the SFT model is then fine-tuned via what is known as PPO, or proximal policy optimization. So simply put, this is how ChatGPT works. It collects data and then fine-tune that data using PPO to achieve a human-like response to the data. Now we may wonder, has ChatGPT come to replace search engines? The answer is no. To understand the reason for the answer, let's compare the two technologies. Search engines are essentially information retrieval systems. They are like superhuman librarians that can find any internet site you want and also recommend other potentially related sites in just a fraction of a second. On the other hand, ChatGPT is merely a language model whose main purpose is to respond to natural language questions and generate text based on the input it receives. So it has not come to replace search engines. They coexist together. Now let's look at cases or instances where ChatGPT have been used. It has been used for cooking inspiration and recipe guidance. For example, the chat not only suggests recipes that we may not have thought of, but also guides us when we have limited ingredients to prepare such tasty recipes. Then it is also used in personalized training plans, in diet plans, and it can also be used to suggest music, movies, and TV shows. And what I found fascinating is that ChatGPT is already incorporated into some applications like the Ask Me application that make use of ChatGPT. Now, let's look at the limitations that ChatGPT face. Because of want of time, we're just looking at two of them. The first one is that sometimes ChatGPT writes plausible sounding but incorrect answers. Let me explain. If the chat is trained to be more cautious, it may cause it to decline questions that it can answer correctly. Also, supervised training can mislead the model because the ideal answer depends on what the model knows, as opposed to what the human demonstrator knows. And another shortcoming or challenges or limitations of ChatGPT is that instead of the chat asking to clarify questions when a user provides an ambiguous query, the current model of ChatGPT usually just guesses what the user intends. On a final note, I would like to say that ChatGPT is one example of how AI is making significant strides in various fields, to the point that ChatGPT now has a paid version and is even open for everyone to use. So although it is still relatively new, it is already making waves. Thank you.
Thank you so much for such a wonderful presentation, Cindy. Am I correct? That's your name, right? Cindy. Nice presentation, wonderful presentation. Group 2 members, you guys did a nice job. I don't know much about the AI or ChatGPT, but from listening to you, I was able to pick one or two things. Your session was really an insightful one. Thank you so much. So I'll be calling on our mentors to give their remarks as regards your presentations. I'll be calling on Mr. Matt Harvey.
Hi, thank you very much. Those were both really, really excellent presentations. So thank you so much for that. I'll take them in reverse order because I've just been thinking about ChatGPT because it was second. A really good presentation, incredibly clear, lots of very interesting technical detail. I must admit, I'm not an expert on how ChatGPT works in detail, so I can't actually comment on the things you said about how it works, and I was finding it extremely interesting. So thank you. I think a really interesting point you raised was about whether it is a replacement for a search engine. And certainly I think commercially, there is a real concern that it is the future of the nature of what a search engine will look like. And so it was reflected in the speed with which Google released its rival platform, Bard. And I think the fluctuations we saw in the share price of Alphabet, Google's owner, really did show just how significant people regard this in terms of the future. And I think you're absolutely right that ChatGPT does not look like a current search engine. It doesn't point you to a website. But I think it is, in fact, more likely to be what we actually really want when we use a search engine. Most of the time, for a search engine, we're looking for a piece of information, and we would rather be able to ask that in a natural way and to get a natural answer as if we were talking to a very knowledgeable person. And I think that is why people are so concerned that they need this level of sophistication in order to compete commercially. You're absolutely right that there'll still be a different kind of search, which is there's a business out there or an artist or someone you want to find, and you just want to be pointed in the right direction. Well, I think Google's trying to combine those two features so that their technology can tell you the source of its information or can point you in the right direction. I mean, as an interesting thought experiment, I haven't actually asked ChatGPT to point me to a website, but I have asked it to give me a list of reading to do, and it's done it very well. You give it a topic and it will tell you what books to read and why. So it's quite close to a search engine in that regard. What is more challenging is I believe ChatGPT's information is all 3 years out of date. And I don't know how quickly it could be updated to be like a search engine, because a search engine has to be bang up to date. You need to be able to find information that's only a day old, or even an hour old, or a minute old. And at the moment, ChatGPT is not able to do that. I wanted to then touch on IP and ChatGPT while we're talking about it. And I think the two controversies there, and I talked about that at the beginning. The first is training data. So ChatGPT and others have been trained on the entire internet. And so for some jurisdictions, I think the UK would be one of them, that's probably copyright infringement. And I don't think there's much debate about it. Now that they did it in the States, probably, so there'll be an interesting issue about whether they've infringed anything in the UK. I think there certainly could be an argument made. In the US, there's a very broad exception for copyright infringement, an open-ended exception under the concept of fair use. And certainly fair use has allowed in the States search engines to reproduce images which would otherwise have been copyright infringements. Now that is not being tested directly, but certainly there's a product called Copilot, which allows people to generate code for a computer using AI. And there is an ongoing case in the States about that. So that will test whether in the US there is an exception for copyright infringement to allow a company such as OpenAI to produce ChatGPT. So it's a very interesting area. And then at the other end, it's the outputs it makes and whether anyone owns them. It seems that outside of the UK and a handful of places, it's unlikely that anyone owns those outputs, anyone controls them. So that's where we are on that. Then the final problem is whether any of those outputs actually infringe copyright in the works it was trained on. And certainly I can tell you from experience, we have clients who are stopping their employees using ChatGPT because they're worried that they will be creating infringing outputs, which would be undesirable. So that's an area to watch. Then turning to the first presentation, again, an excellent presentation, very complicated area you tackled. You gave a very good outline of the forms of IP and of the critical issues. I would say the topics you dealt with are matters of debate, and so there may not be anyone who knows the right answer in some regards. I would personally take issue with some of your conclusions on copyright. I think it's absolutely the case that if a human has written a computer code, it is a copyright work, and you are absolutely right to distinguish between the ideas and the expression, and that's how it works, at least in Europe. That I have copyright in the program I've written, but I can't stop people copying the ideas or the principles of how it works. They just can't use the programming that I've written myself in the way I chose to write it. I think when it comes to AI, and you may not have been saying this, but I think training data can be a copyright work if it's a photograph or an article or something. But to the extent it's just information, if I'm training it on, I don't know, data taken from a sensor of temperature and things like that, then that probably isn't a copyright source material. I also think that where a computer generates the model, which is how a neural network operates, for example, and many forms of machine learning, where a computer generates code in the form of a neural network or some other device, if there's a strong argument that isn't protected as copyright. And so where you're left then is relying on patents, and you're absolutely right, massive growth in patents relating to AI or trade secrets. And I was very glad to see you mention trade secrets. That is an incredibly significant form of IP for AI, and one that I think I read the other day that there is now more trade secret litigation in America than there is patent litigation. I don't know if it's true, but it certainly is a sign of the growing importance of trade secrets because of the difficulty in protecting data and algorithms, the outputs of AI through other forms of IP. So I thought that was all excellent. Then on patents, and I think Benjamin may well be more of an expert on patents than I am, but briefly I would say it's very interesting that we have many, many, many patents relating to AI, but very little litigation about it. And I think it is broadly possibly the case that patents relating to AI may be relatively hard to prove that there is infringement, or it may be relatively easy for people to work around other people's patents. And relative to many areas of IP, they may not be enforced that much in the years to come. And then finally, you raised the very difficult topic of ownership of inventions or creative works by AI. And I think it's very important to distinguish whether anyone thinks the AI itself should have any rights. And that is, I don't think many countries are considering that. There are even some countries such as France, which have talked about literally making it part of a constitution that must never happen. So the real question first is, should there be any protection at all? And that's, in my jurisdiction, that's what we would call subsistence. Should copyright exist? Should that invention be patentable? And as a wholly separate issue, who should own it as a result? And generally, the way that would work is you don't need AI to own it. If its output is either patentable or could be copyright, you need some sort of default rule about who should own it. And the way it's been tackled with copyright works in the UK and in other jurisdictions is it's the person who makes the arrangements. Now, that's a little bit similar to your conclusion, which to give under Caesar, etc. I think what you were saying was the person who owns the AI should own its inventions. I think that's what you were saying. And that's broadly the sort of default rule you need. And then you allow people to enter into contracts if they want a different arrangement. So if I wanted to, let's say the outputs of ChatGPT were copyright, it would depend on the terms of my agreement with them, who would actually own it. So you're not tied to the default rules and legislation, but you need something there in case there's no agreement. But if you make an agreement, you can make sure you've got a suitable solution for who owns any copyright. So in conclusion, really fantastic presentations from both of you, and thank you so much.
Thank you so much, sir, for your observation. Mr. Benjamin Mark, do you have anything to tell us as regards their presentation?
Yes, thank you all. And Matt raised a lot of good points that I will not repeat. But those are actually the most important issues that we are considering today, being the identification of the IP and then the ownership of the IP. In terms of data, think of like a security camera that you just leave up who owns the copyright in that. It is video, so it, could be an artistic story, but it might just be out there. Or think of I think some giving like a monkey a camera and letting the monkey take the pictures. Well, was that just an accident, or does the person who gave the camera as a thought experiment own it? So these sort of issues have sort of arisen, and the courts have tried to decide it. So I mean, I not to repeat anything. So then, just going back to property law 101, it is true, right? If the machine owns the IP, then you may have to go back to the first owner of that machine, and then that owner is really the owner. And so, the owner of the camera, let's say, who set it up and did some time-elapse photo or security photo, maybe. So in property law, it is, what do you do with that? So in basic properties, you would say the owner gets the use and the fruits of the IP. That's what the first owner gets. So the first owner is the machine. You may be able to set up some system of transferring and licensing, let's say, but right, who would own the money? Who would own the consideration that the machine would get back when exploding the IP? And even if they sell or transfer it, who gets the sale price? So it's probably not the machine then. So you get this weird separation of the owner, assuming you're naming the machine as the author, let's say, versus the owner of that machine, who is really the person who could exploit it, who can transfer it, who can license it, and who could sell the IP. So I think that's kind of part of the struggle, just the first principle, because in all of IP, the first author is usually the first owner as well, right? Unless there's an agreement to the contrary. So you're kind of just saying, just the fact that I have a receipt that said I owned that computer or that cloud account, then I guess I'm the owner, right? And then so there's some weird transfer of ownership that needs to occur. So that's the property lesson today. Yeah, for patent infringement, yeah, detectability. Of course, the machine learning model is just with the trained weights. It's hard to find and hard to detect. I think someone may have mentioned the first presentation about like watermarking, and well, these are things you can do through your AI model to, if someone literally copies it and runs your machine learning model, there may be ways to detect through it. Otherwise, yes, your patent would probably be better served to look at more front end or detectable things. And of course, for machine learning, the secret sauce is usually in the back end. But as I said, infringement and detectability are better served on the front end. So we sort of have the Goldilocks paradox, where you kind of want the perfect storm and the perfect fit of getting some newness in the front end, whether it's your inputs, your outputs, or some sort of detectable feature on the screen or on the end device that you can actually audit and go through. But the more easier patents tend to be the brains or the guts of the machine learning model, which is the back end, which is harder to explain. But sometimes they do go through, or sometimes you can try to get discovery of the back end and things like that. So that's sort of how the usefulness of an AI based patent can be done. I mean, it's not like there'll be no litigation. There'll probably be some, and it's kind of, you try to draft the claims to all features ideally, which is from the front end or the user devices, from the back end, and maybe the whole system and some methods and things like that. So that's sort of how we approach the patents, and hopefully that you can, if you guys end up drafting patents and looking at patents, that you try to at least cover it from all aspects and then just see what the patent gives you. But you try to really cover end to end and then claim the right components that you can find infringers. But yeah, but both presentations spurred a lot of conversation and debate. Right, the last thing about the ChatGPT. So yeah, I mean, maybe this is my personal experience or what I've read online, but I think the owner of the output, it may be dependent on the nature of the input. So if I just put cat poem and let it run, right? It's tough to be the owner of that copyright. But let's just say the more creativity and the more you put in, or it's I want to write a script, and here's the characters, and here's what they do, and I want a fight scene in the middle, and this and that. Maybe there is an argument. As unfortunately, I haven't looked at the law too deeply, that the outputs then become the person who put in the input, even though ChatGPT really created it at the end. Or I want to create a painting using DALL-E, sorry, and then you explain it in words in so much detail, or you feed it the book that you wrote, and I say I want a picture that reflects this book I wrote. And so I mean, it's for some of these there may be some strong argument that you are the owner, even though you just use the model. This may be just my opinion, so don't fight me at that. So that's my third point. So hopefully these 3 points are of assistance to you in the future.
Thank you so much, sir. Thank you, Mr. Benjamin. Mr. Felix, any observations as regards their presentation?
Okay, so thank you so much for the presentation. I think that was a quite brilliant presentation. Naturally, I have a lot of comments, but again, I consider Benjamin and Mant have spoken about a few of them, so I will not want to repeat the points that have been raised by both of them. But essentially, I would like to speak to the aspect of ownership and liability when it comes to intellectual property created by artificial intelligence. Now, based on the presentation, it was quite clear that two schools of thought was actually advanced in the presentation, that you have IP solely created by human beings and those created by both human being and artificial intelligence. But again, we all understand that they may not be a commonplace now as we currently discuss. There are also intellectual property created exclusively by artificial intelligence. I personally do not want to believe that you only have two schools of thought, or let me say two instances. I mean, those created solely by human beings and those created jointly by artificial intelligence and human beings, in which case you can be talking about ownership rights by human beings involved in this process. But again, we need to ask ourselves, what about intellectual property created exclusively by artificial intelligence? I do not personally want to believe that such piece of work should be left ownerless, in such instance that no one will have any claim over them. So, and I'm going to link this to how it applies to the aspect of liability, which of course you mentioned during the presentation. I believe that as long as you have chain of causation or chain of ownership, which is straight from the human being who created the artificial intelligence and which in turn was responsible for the creation of intellectual property. Such intellectual property, such ownership of intellectual property should actually be ascribable to the human being responsing the device together in the first place. Because if we have situations where intellectual property created by artificial intelligence exclusively is left to be ownerless, we will almost be creating a place where there will be a chaos, and which should not be controlled by law, or in which people responsible for configuration or putting together the artificial intelligence devices will indirectly be deprived of having the benefits of the work they have done, and which I believe in the long run is going to run roughshod of the intention of the law of intellectual property. And I think that directly takes me to the aspect of liability. And I think this is going to make it quite clear in this sense. Now let's flip it. Let's assume for the purposes of argument that it is possible for intellectual property work created by artificial intelligence may be ownerless, in the sense that we can declare that such is not owned by anybody because no human involvement is actually took place for the purposes of creation. Now, if such intellectual property is now responsible for causing some liability, for example, let's say a driverless car, which of course in some instances we have seen in the United States actually killed a woman to that extent that because it was an artificial intelligence, or let's assume for the purposes of assumption that such piece of work was exclusively created by artificial intelligence, and in such instance, no one will be held liable. I don't think that actually makes sense. So for the purposes of establishing liability, then it makes it extremely important that we have to establish ownership. Otherwise, such intellectual property, which is capable of causing liability or probably invoking some liability, when such happens, then it will be impossible to establish culpability, and that will defeat the whole essence of law. Then again, let me speak more specifically and not be theoretical, maybe practically with aspect of responsibility for liability, or let me say injury caused by artificial intelligence work. So there have been examples. I remember writing a very short article on the death of a pedestrian in the US who was actually knocked down by a driverless car. Unfortunately, this case did not go to court because there was a private settlement between Uber, which deployed the car, and the family of the deceased. And unfortunately, again, no criminal charge was actually pressed against the company responsible. But again, we can begin to think, because I believe that for the fact that the private settlement, which led to the settlement, or let me say the closure of this case, it indicates subtly to us that there's a possibility that Uber, which deployed the car, will be responsible if the case was to go to court. Now, you have a whole lot of, let me say, interplay or a network of parties responsible for such situation. For example, driverless car that I'm talking about. So you have the company, in this instance, it was Volvo, which actually made the car. You have another party, which was, then you have Uber, which actually deployed the car, and you have maybe insurance company, which actually insured this car. And so for the purposes of establishing culpability and responsibility for such liability, I believe even though the extent, the spectrum of law has not been extended to cover some novel developments, which may be forming some complexity in this regard, the current status of law actually to some extent addresses all the issues which may be arising from such liability. As the duty of care under the law of tort to ensure that this does not, or the car does not knock down a pedestrian. And in such instance also, the company has the responsibility to ensure that the car is insured, so that if such eventuality later takes place, the victim will be compensated. And I also believe that Volvo, which was responsible for making the driverless car, should actually be responsible for a duty of care to the extent that the configuration is accurate enough in order to ensure that the sensor works and understand the fact that if a pedestrian is crossing, there should be mechanism put in place that will make the car to stop and not knock down a pedestrian. Unfortunately, this has not been adjudicated in court, and we may not have currently the principle that will address this issue. But I personally believe that currently the position of law may not be extremely or abundantly, let me say, sufficient enough to address these issues. But I believe that the current state of law to some extent still apportion liability where such issue occurs. And so the fact that AI is actually responsible for injury on a third party to configure it, because currently all over the world, there's no law that has recognized artificial intelligence as a legal personality. And to that extent, artificial intelligence cannot be responsible for ownership of any intellectual work or any property whatsoever. And we can see some viewpoints from even the case of, I think, Nakaku and Naruto in the US, where a gorilla actually took some pictures using the camera of a gentleman who actually visited the zoo. And now the ownership of this, or let me say the management of this zoo actually claim that this picture should belong to the gorilla, which is actually in the cargo. But the position of court is that an animal is not, it does not have legal personality. And to that extent, it is not the owner of the camera that should actually be responsible or should be the owner of the picture. Because when you create the work of intellectual property, it is not what is used to create the intellectual property that determines the ownership. It is actually the intelligence. It is the expression that creates the intellectual property that determines who owns it. And what this means is that if I'm a visual artist and I take your pen and I decide to make a drawing on the wall, so the work of art that I make on the wall actually belongs to me, irrespective of the fact that it's your pen that I took to draw the picture, or probably to make the work of art on the wall. And so the court followed this reasoning to say that the owner of the camera cannot be the owner of the picture. And unfortunately, because the gorilla also cannot have the right to own intellectual property because it is not considered as a person with legal personality. And so such picture was actually declared to be ownerless. And I'm looking at this principle and of course the reasoning of the court in this case, that same extend to a position where intellectual property is made by an artificial intelligence device. In such instance, the longer we can stretch this argument, would be probable to say that the owner of the intellectual property who actually deploy it, configure it, should reasonably be considered to be the owner of the intellectual property created by the artificial intelligence. But we must all agree that this argument needs to continue. The position of the law is still quite emerging, and we'll continue to see how the law advances as companies or as countries of the world continuing to be aware and cognizant of the potentials and the capacities of artificial intelligence to actually affect our every area of life, including the advancement of our law. And so far, I think it's been an interesting session. And thank you so much for the presentation.
Thank you so much, Mr. Felix, for your observation. Before we get to the question and answer section, I want all mentees to turn on their cameras, to take pictures, so I can take screenshots. This will be very useful if you're very active on LinkedIn and other social media handles. You can, post the screenshots later to, tell your connections on LinkedIn that you are here this evening and you listened and you gained from this session. So please turn on your cameras. I don't know why you're frowning, Miracle. Please smile. Please smile. Please smile. I'm taking screenshots right now. Mr. Hussein, please smile. Mr. Joseph, please smile. Thank you. I'm taking screenshots right now. Okay. Thank you so much for listening and turning on your cameras. So mentees, this was a very insightful section with lots and lots of controversies, starting from IP and AI down to ChatGPT. So I just want to ask, do you have any questions whatsoever as regards this? Our wonderful mentors are here to listen and answer your questions. So mentees, if you have any questions, please raise up your hands or you could text on the chat box. Any questions? God's love, do you have questions? Cindy, do you have questions? Okay, Miracle, you can unmute yourself and ask your question.
Okay, good evening, everyone. Yes, my question is coming from what he just said now. He said something about a particular case scenario that held in court, and the court said the person that nobody has ownership over that property because it was not made by a human being. So I'm not comfortable with that, though I believe the law is still progressing. Maybe a time it comes, they will give a different ruling in regards to property created by non-humans and stuff like that. Because with regards to a company now, a company, I'm trying to relate it. A company is a legal personality that you cannot just say this is a company. So whenever there is any, and the company is liable for whatever crime or whatever civil liability, the board of directors take responsibility because they are assumed as the owner of the company. So I think that should also play out with regards to stuff created by artificial intelligence. Can't the owner, the person who made the intelligent effort involved in the creation of that artificial intelligence structure rather, can't that person take responsibility, liability, or even interest that accrues to him by as the person who created that structure? I just hope I'm gotten clear.
Okay, Miracle, I want to be sure I understand your question. Is your question on who should be liable where an AI infringes on IP rights? Is that your question? I want to be sure I got you correctly.
My question is, the expression that because it was not a human being that created that property, so that means that property has no owner. That is my concern. Has no owner. I feel responsible for the creation to be the owner of the property.
Okay. So mentors, I don't know who was willing to help us with this. Mr. Mathavi.
I can give it a go. So I understood the question to be, if there's no intellectual property in the output of an AI, is anyone liable if it's an infringement of someone else's IP? I think that was the question. I don't think the two are related. So I can infringe someone else's copyright without creating something that's worthy of copyright protection myself. And the obvious example of that is if I make a direct copy of something they've done and I've added nothing. Equally, I can add something of my own, get my own copyright, but it's still an infringement. So I don't think the way our legal system works that I need to say that the output is owned by someone or attracts IP in order for it to be an infringement. Whether there is an infringement when we come to copyright is actually a really difficult question, because there are two kinds of intellectual property. There is a monopoly right, and a patent gives you a monopoly right. And that means even if I had never heard of your invention, if I do the same thing, I'm not allowed to. Now, copyright requires me to have actually to have copied your work. And if the AI, for example, creates a similar work by coincidence, it's not a copy. And it's not copyright infringement. So there will be complicated questions about whether the AI was trained on the work that it's alleged to have copied, and when these AI models are trained on literally millions or billions of images, it may be a complicated question to figure out if they've actually infringed any specific work. And then there's the further complexity of who's responsible. And this is a new factual scenario, because it used to be that in order to get an image, I had to draw it myself or I had to instruct an artist to do it, but we both did a deliberate act. Now we have a virtual artist in the AI, and it's more like the scenario where, and I don't know what the equivalent is in various jurisdictions, but in the UK, the key case was about a double tape machine, which allowed you to record from an original tape a copy. And because it had legitimate uses, the manufacturer of that equipment wasn't liable for the copies which were made with it, because there are many legitimate reasons why you'd want two tape decks. Now with ChatGPT and other generative AI, there'll be two questions. One, because they've trained it on all this work, are they liable for what it does with it? And secondly, if you have asked it to make an infringing copy of something, despite maybe their terms and conditions asking you not to do that, are they still liable in some way? Or can they push the liability onto their users for having used the software to make an infringing work? And what you're seeing is certainly in the terms of conditions for DALL-E 2 and other generative AI, there are both terms and conditions asking you not to make infringing works or violent works or unsuitable works. And there are also some filters involved to try to prevent you doing that sort of thing.
Thank you so much, sir. Miracle,
Sure.
hope your question was answered.
Thank you, sir. I appreciate it.
Okay. So, God's love, Kamalo, your hands are raised up. You can unmute yourself and ask your question.
Okay, thank you very much. My question is actually with regards to ChatGPT and looking at IP infringement over time. And with regards to, we know that humans, we enjoy this thing where when something comes on board and something that makes life really easy for us, we tend to tilt towards it. The question now is, can someone copyright the work from ChatGPT as theirs? Because people would say that they did the research and the research, they found this. Okay, from the research, they are, should I say, in copywriting, they are actually enlarging or adding more novelty to a work already, but then they are actually adding more research to the work to make it more new and more original. And then this research actually comes from ChatGPT. So what level then would IP protection stay, and how original would we have works then if humans can rely on ChatGPT to do their work for them? What happens to originality then and IP when it comes to copyright?
Yeah, this is a huge question. It will be different in different countries as well, the answer, and no one is sure at all. So to give you an example from the UK, first of all, let us assume that what you asked it to do is insufficient to make you an author. Then the question is the output of ChatGPT acting on its own protectable by copyright? In the vast majority of countries, that's a definite no. In the UK and some other countries, our laws say that is protected, but even there's some uncertainty that our law will actually work, because we now have a test for originality, which is about the author's own intellectual creation, which doesn't seem to be appropriate for an AI. So we're not even sure in the UK, where we say we protect those works, if the output of an AI is protected. So then returning to the other possibility, that the input you put into ChatGPT is sufficient that you are treated as an author, and at that point the ownership would be yours. Now that's creating a lot of dispute as well as to how that should work. In the UK, if you look back in time to cases not related to AI, there are a small number of cases where a person has instructed an artist to draw a picture for them. And they have suggested the person giving instructions to an artist could be a joint author with the artist if they were giving very detailed instructions for what they wanted. So the principle could work, that if I put a detailed instruction to ChatGPT and essentially told it what kind of expression I wanted it to use, I might qualify as an author. The only place that has been tested so far is in the United States in relation to a graphic novel. If you look on social media at the moment, I imagine you'll find the story. But essentially, the the person who made that graphic novel has been allowed to have copyright in the words and the overall graphic novel, but the individual images which they used AI, they do not own that copyright. So that's the current situation, but it's huge debate and it will come out differently in different countries.
Okay, sir, I think we lost God's love, but I hope his question was answered before we lost him. Thank you so much, our mentors, Mr. Mathavi, Mr. Felix, and I think we lost Mr. Benjamin because he said he had other things to do. Thank you so much. This was really insightful. For someone that knows little or nothing on AI, I was able to learn a whole lot. Mentees, don't stop here. You could go ahead to, research, and don't just research. You can even write articles, works, publish on Medium and other apps and all that. Do well to make your researches. Connect with your mentors on LinkedIn. Try to reach out to them. Thank you so much. This was very insightful. I'll be calling on Mr. Joseph, the co-founder of JIIPCC, to give us our closing address.
It's really great to be here. Thank you so very much, Delight. Thank you, Mr. Hussein. I want to say very resounding thank you to all our mentors who were able to meet up today. I listened in for much of today's presentations by both the mentees and, of course, the responses by the mentors. And I must say that personally, my knowledge of this area is improving by the day by being part of this particular program. So it's really an opportunity for us to take the frontiers of this conversation further. And it's been quite enlightening knowing about certain case values in terms of what the application is in the United States and, of course, in the UK. So thank you so much to our mentors and, of course, to our mentees for the presentation, for the teamwork, for the hard work, for coming together to put all of this together and for making your presentations. Thanks a lot as well. I'm very happy of how far we've come in this program. And I know that the weeks ahead would be more tedious and more exciting at the same time. So I just want to encourage us. Let's see how we can continue to communicate with one another, engage with the mentors. The mentors are actually there for us to reach out to and for us to share knowledge and for us to deepen our understanding of artificial intelligence. So the beauty basically is when you reach out and when you engage further beyond the closure of this particular program, that's where you actually get much of the value. So I want to just encourage us. Let's see how we can raise the conversations on LinkedIn, tag your mentors, and let's see how we can push, the conversations around AI to the next level. Not everybody is hearing about AI, but very few people really understand the issues within artificial intelligence. So it will be a good time. Let's keep having those conversations on social media, on LinkedIn, on Instagram, on as many social platforms as possible. And please talk to your friends about it. Let them know what's really going on the program. And I'm sure that for as many people who go through the JIIPC mentorship program, they are a whole lot better than when they actually started. So this is actually a big thank you to each and every one of us for being part of the program today. And thank you once again. Delight, over to you. Thank you.
Thank you so much, Mr. Joseph, for your closing address. Once again, I want to say a very big thank you to our mentors. Mr. Mathavi, I learned a whole lot from you, and just all of us that will be connecting on LinkedIn. Mr. Felix, very, very insightful section. Thank you so much. Mentees that put in the work. Thank you so much. Very amazing sections. That will be all for tonight. Do have a lovely night. Thank you.
Good night.
Bye, everybody.